Good afternoon. My name is Neil Siegel, and I co-direct the program in public law here at Duke Law School, and I'm very pleased today to introduce Srinivasan, who is, without exaggeration, the greatest Supreme Court advocate in the history of the Supreme Court of the United States. And therefore, there is no pressure on him today to perform beyond our wildest imaginations. He is one of the young emerging stars of the Supreme Court bar. He's argued, 17 cases now, and I think 5 very, very recently. Is that right?
No.
He's a former law clerk to Justice O'Connor, as well as a clerk to Judge J. Harvey Wilkinson on the Fourth Circuit. He's an appellate lawyer at O'Melveny and Myers in Washington, D.C., as well as a former assistant to the Solicitor General of the United States. And so we're very pleased to have him here at Duke Law School. He's going to speak to us about statutory interpretation and Supreme Court advocacy in statutory interpretation cases. He also happens to be a very big Duke basketball fan on a day in which the men's team is playing Michigan State, and so I imagine if you have questions about that, he'll be interested in talking about his affiliations with Kansas and Kansas basketball as well. Without further ado, Sri.
Thank you very much. It's really a treat to be here at Duke. I'm very fond of this place. I'm very fond of Neil too, so those of you who have had the pleasure of having him for a class are undoubtedly exceptionally lucky students. I know that I wish I could have had a professor with that kind of energy and enthusiasm when I was in law school. I had a few, but Neil would have been certainly a star at Stanford where I went to school. It's terrific to be here and to talk about something that's really exciting to me personally. Arguing in the Supreme Court and arguing statutory interpretation cases in particular. And I'd like this to be somewhat collaborative, and I see that some things haven't changed a great deal since I was in law school, which is that everybody really angles for the front row seats and nobody pushes their way to the back. But even though you're not sitting in the front, if anybody has a question at any point while I'm going through a few points that I threw together, please do raise your hand and chime in. And I think I'm going to actually ask a few questions at the outset just to stimulate a little bit of dialogue, if I could. Let me ask one question, just as a show of hands. How many people here have seen a Supreme Court argument? That's a good number. How many have at least listened to one? Okay, that's terrific. So basically, almost everybody here. One thing I always like to say at the outset when I talk about the court is something that seems obvious, but I think is a little bit underappreciated and undermentioned at least, and that is that it's a terrific privilege to get to argue at the court for a variety of reasons, but in no small part because it is an extraordinary collection of lawyers. And I think no matter what one thinks about the decisions that the court makes in a particular case and whether we agree with it or disagree with it, agree with the methodology, disagree with the methodology, one thing we all should really respect is that if the goal of composing a Supreme Court is to come up with a who's who list of lawyers, of extraordinary legal minds, and of people who are unbelievably dedicated and engaged, that goal has been achieved. I mean, because this is a remarkable court. All 9 justices are just exceptional lawyers, and one can really, I know Don Ayer is here who's argued many times before the court, and I'm sure Don would say the same thing, that the back and forth at argument tells you how unbelievably talented these lawyers are, because almost in every case that I've argued, I get questions that it took me and my team several weeks, if not months, to get our minds around in the span of a few minutes of argument. And the justices have to prepare not just for your argument, but for arguments in a number of cases. They're obviously dealing with all kinds of issues at the same time, writing opinions and whatnot. And the fact that they are as wonderfully talented and as dedicated as they are, I think speaks remarkably well for the institution, and it leads to a really interesting body of decisional law. Now, I thought what I'd do today in talking about statutory interpretation cases and the court is to first talk about formulating a position in a statutory interpretation case. What are the considerations that we take into account? How do we formulate a position? And then talk about articulating that position at argument. Obviously, the two go hand in hand, but it seems to me to be beneficial to speak in terms of formulating it at the outset and then articulating it at the back end. Now, in terms of formulating a position, almost every statutory interpretation case obviously starts with the terms of the provision that's at issue, and you're trying to formulate a rule. And there are usually competing rules that one can choose among. Usually there's been a lot of decisional law in the area. Lower courts have probably pronounced on it a number of times. And so you're going to have a body of decisional law that you can draw from. But there are certain characteristics in a rule that one should be looking for in trying to identify what particular rule are we going to put forward to the court as our first order submission. And let me talk, just give a little bit of background on a couple of cases that I argued last term, which I'll try to use as examples as we go about trying to gain an understanding of how we formulate a position and then how we articulate it. One case was a case called Hertz versus Friend, which how many of you have had federal courts, or at least civil procedure? How about civil procedure? Okay, so everybody here knows what diversity jurisdiction is. And everybody here understands the sort of basic purposes of diversity jurisdiction. Now, surprisingly, for decades, there was quite a bit of disarray in the lower courts on a question that was addressed in the Hertz case last term, which is how do you define a corporation's state of citizenship? And what the statute says is that a corporation is a citizen of the state where it has its principal place of business. So clearly the test is principal place of business. And then the question is, how do you define a corporation's principal place of business? So what we're trying to do is trying to formulate a rule that adheres to the text and that's going to be attractive to the court on what a corporation's principal place of business is. So keep that in mind as we go through some thought experiments about formulating a rule. The other case I'll touch on, not probably to the same extent, because I think although it's a fascinating case in many respects, it's not as useful in sort of talking about formulating a rule, is the Skilling case. And actually Don argued a case that was closely related called Wayrack. And the issue in those cases concern the proper construction of the so-called honest services fraud statute, which some of you may have read something about. But basically the honest services fraud statute added a layer to what was traditional fraud under federal law. Traditionally, fraud was incorporated the deprivation of money or property. So you obtained money from somebody by defrauding them. You obtained property from someone by defrauding them. What the honest services fraud statute did was it added an additional type of fraud, which is the deprivation of the intangible right of honest services. Now that's a little bit of a mouthful, but really what it's trying to get at is situations in which public officials, for example, might take a bribe. They take a bribe. What the victim is being deprived of there is not money or property, really, because obviously the person who pays the bribe wants something to happen. They're not being really deprived of something. But the body that's being deprived of something is the public. And what they're being deprived of, in Congress's view, is so-called intangible honest services, the idea that public officials owe everybody an obligation to perform their duties in a way that's honest. And when you've accepted a bribe as a public official, what you've done, allegedly, is deprive the public of its right of honest services. So keep that in mind as well, because we may be drawing on that a little bit as we go through the formulation of a rule. So let's talk about formulating a rule. We want to formulate a rule, and let's use the Hertz case as an example. We want to formulate a rule on how you define a corporation's principal place of business. There's lots of rules that one can imagine. The one that we articulated and pressed and that ultimately the court accepted was that in every situation, the corporation's principal place of business is the place where it has its headquarters. Now, there's some strengths to that, there's some weaknesses to that, but there are some competing approaches as well. And some of the competing approaches focused on where does a corporation do its business? Not necessarily where is its headquarters, but where does it actually do business? Where does it sell product? Where does it have employees? Where does it have physical plant? Considerations of that variety. So can someone tell me, if I'm trying to formulate a rule, and those are two sort of poles on the spectrum of rules that we might defend, if I'm trying to formulate a rule that's going to persuade the court, what are some of the things that I want to be thinking about in arriving at that rule? Sure. Ease of application for lower courts. Yep, that is very, very important. And I think, especially at the Supreme Court, I think even more so than in other courts, ease of administration and clarity are really, really important considerations. And you see this all the time at argument. How is this rule going to work in practice? Are there too many caveats? Is it subject to a great degree of manipulation? Is the type of thing that lower courts are going to be able to fasten their minds around in a way that leads to predictable results? Or are you going to have lower courts looking at a rule and reaching different results even in the same situation? Because obviously the reason a case comes up to the Supreme Court in the first place is that oftentimes there's disarray in the lower courts. So the court's going to be hard-pressed to arrive at a rule that leaves that disarray in place. They want to come up with one that's very clear and administrable. That's a really important one. What else? What else are we looking for in a rule? Your hand's halfway up. That's good enough. Yeah, that's really important too. Purposes, intent. I think you can look at it as purpose. You can look at it as legislative history. That's obviously you'd like to be consistent in your rule with what Congress is trying to achieve. That's a good one. Yep, precedent is important, and by precedent you mean decisional precedent. Yeah, that's important. Now I want to talk about this in a little bit. Decisional precedent is important, and I think you can look at it in one of two ways. You could say it has to be consistent with precedent, or maybe what I would say is at least it has to be not inconsistent with precedent. I think precedent at the Supreme Court, there's two types of precedent. There's Supreme Court precedent and there's lower court precedent. I think precedent at the Supreme Court in a statutory interpretation case may be overvalued a bit in argument generally, but it is certainly a consideration that you want to take into account. And obviously you're in deep trouble if the rule that you're putting forward is contrary to precedent. That is not a good place to be. What else? What else can we think of? There's one that's so obvious that it probably, please. Yeah, the text. I mean, you want to be consistent with the text. Again, what I would say is you want to be consistent with I would say is you don't want to be inconsistent with the text. I mean, obviously, the more consistent you are with the text, the better. But all these considerations can point in slightly different directions. So if you have a rule that's readily administrable, and it's clearly more administrable than a competing approach, then you might be able to give a little on text or precedent and still put forward that rule because it's going to be attractive, because it's practically feasible. There's another consideration that probably is so obvious that it doesn't even bear mentioning, but I'll mention it anyways. And that is, ideally, you'd like your rule to be one under which you'd win, right? Now I say that and I smile, but you'd be surprised how often you try to arrive at a rule, you look at all the competing considerations, you try to arrive at a rule, and you lose sight of the fact that actually under the rule that seems the best, it's not clear what the result is in your case. So that, I think, is probably the number one objective. Make sure you come up with a rule under which you win. The other ones, I think, are really, really important. Is it administrable? Is it clear? That's really important. Is it not inconsistent with the text or consistent with the text? That's really important. Is it consistent with statutory purposes? That's very important. And decisional precedent is a salient consideration as well. Now, one thing I'll say about statutory purposes, one consideration that sort of wraps into that is, does your rule lead to sensible outcomes? And by sensible, I mean consistent with legislative purpose. But a lot of times we run into a situation where you have a rule that sounds good, it sounds like it's going to lead to results that are consistent with what the legislature intended, but then there's some sort of off-the-wall applications where the rule just doesn't make sense because it doesn't fence out the stuff that seems like it should be fenced out, and it doesn't fence in the stuff that seems like it should be fenced in. So I think sensible outcomes are a really, really important consideration at the Supreme Court, as is clarity and administrability of the rule. Now, what about the Hertz case? So where do we come off on some of this? If we take up the consideration of administrability and simplicity, which, as I said before, I think is a really, really important consideration at the court, we thought that the fact that we had a rule that focused on one consideration and one consideration alone, where does the headquarters exist, was really good on that metric. Now, of course, there are ambiguities about where a headquarters is. I mean, you can imagine situations where you have two CEOs, co-CEOs, one lives in Birmingham, one lives in Durham. Where's the headquarters of that company? So there's going to be some ambiguity around the edges. You can concoct hypotheticals where even the location of a headquarters can lead to some ambiguity. But compared to the alternative, it seems like it's really, really a winning proposition on that score. The alternative, what most of the lower courts had done, and just to set the table a little bit, one court of appeals, the Seventh Circuit, had adopted a rule that was coincident with ours, which is to say that it's the headquarters in every situation. No other court of appeals had embraced that position. Now this gets to the point that was made about decisional precedent. Is it consistent with precedent? Well, that sort of points in a different direction, because there's only one court that had said that it's headquarters in all situations, and 8 courts of appeals had rejected that approach. So it's not terribly consistent with at least Court of Appeals precedent. The Supreme Court hadn't looked at the issue yet, but it's not terribly consistent with Court of Appeals precedent. So here you have these considerations sort of bumping into one another. But we thought administrative simplicity and clarity was really important. The court had said that it's really important in the jurisdictional area in particular. The idea being that with subject matter jurisdiction and diversity jurisdiction, you don't want to spend a great deal of time with nebulous inquiries on that because it prevents you from getting to the merits. So there's a real premium placed on clarity and simplicity at the outset with jurisdictional rules. And then let's get on to the real meat of the issue, the merits of the case. So now let's think about simplicity with respect to the completing approaches. So if you think about what a principal place of business is, I think what one ordinarily connotes in the mind, or at least what many people do, is where does a company do a bulk of its business? And that's what a lot of the lower courts had looked at. They had rejected the headquarters across the board rule, and they had said, well, let's look at where companies really do business. Let's look at where they sell a lot of goods. Let's look at where they have a lot of employees. Let's look at where they have huge physical plants. But if you start peeling back on that a bit, you run into a host of ambiguities right at the outset. For example, what time frame are we looking at? You can look at where a company sells a lot of goods. It may be that they sold a lot of goods in Virginia in one year, and then the next year, for whatever reason, liberalization of regulations in some other state, or something that makes business more friendly there. Maybe things shift, and you're selling a lot of product in a different state. So that really compromises clarity, because you could have something that waxes and wanes based on regulations in one particular state. What about number of employees? Well, how do we count employees? Do you do it in terms of, do you count part-time people? Do you only count full-time people? Again, these are sorts of ambiguities. What about revenues? For those of you that have had accounting, do you use the accrual method? Do you use the cash method? I mean, there's all sorts of ambiguities that attend any approach that looks at business levels. So we really thought that there was an advantage to be gained in terms of simplicity and clarity to an extent that it outweighed some of the disadvantages vis-a-vis some of the other considerations. Now, how about whether there's sensible outcomes and whether it's consistent with purpose? Here you run into a little bit of an issue. For example, the other side, I thought, came up with a pretty darn good hypothetical. How many of you have been to the Venetian casino? How many of you have been to Vegas? You can admit it. What happens in Vegas stays in Vegas, so you can admit it. So the Venetian casino happens to be a former client of mine in a previous life. The hypothetical that was used by the other side was, you have the Venetian casino, which obviously does everything in Vegas, not Venice. It does everything in Vegas. Suppose the Venetian casino decided that it was going to relocate its CEO to Phoenix, Arizona. Now, under our rule, we would say headquarters governs in every situation. So the principal place of business of the Venetian casino is Phoenix, Arizona. Now, they said, that's crazy. The Venetian casino is in Vegas. All the business is done in Vegas. Nobody goes to see the CEO in Phoenix. Everything is done in Las Vegas. All the customers are there. All the physical plant is there. All the transactions are done there. All the gambling is done there. All the shopping is done there. Everything is done in Vegas. How can you possibly say that the principal place of business of Venetian casino is Phoenix when, in fact, everything of consequence is done in Las Vegas? So that's a pretty fair point, I think. And that's something that we had to contend with. So you have sort of sensibility of outcomes pointing in an opposite direction based on that hypothetical. And your goal in that situation is, can we come up with something defensible that abuts that? Because we think we have such a strong case on administrability and simplicity that what we want to do is come up with something that's defensible. And we thought we did. Something that's defensible is to say, look, it's true, all the business is conducted in Las Vegas. But still, Venetian casino could turn into the Venetian laundromat if the CEO in Phoenix decided that it was going to be a laundromat instead of a casino. So the principal place of business, and here you can take into account text, principal meaning most important, most influential, is still Phoenix. Even though there's only one person there, that's the most important, most influential person. And if she says the business in Las Vegas is now going to be a laundromat instead of a casino, well, that seems pretty consequential. So we at least had what I thought was a defensible response to what otherwise seems like a very difficult hypothetical for us. So what this goes to show is you take into account all these considerations in formulating a rule, and sometimes the considerations are going to point in one direction, sometimes the considerations are going to point in a different direction, but you want to consider the totality of them and figure out which rule makes the most sense across all of them and which is going to be most saleable to the court. Now, legislative purposes, this was a tricky one for us too with diversity jurisdiction. As everybody in the room knows, the purpose of diversity jurisdiction really is to avoid homerism, which is to say, you want to avoid a situation in which an out-of-state corporation is discriminated against by the state system, whether it be the courts or the juries, and you want to give the defendant company an opportunity to get in federal court where the perception is that they would have a fairer audience. So the idea at the outset was if you have a company that does all its business in, say, Alabama, and then it's sued in Alabama, well, there's not really that much of a danger that they're going to be subject to discrimination there because everybody is going to know the company. It's an in-state company. But if that company is sued in Kentucky by Kentucky plaintiffs, there's some danger that they would be subject to discrimination as an out-of-state company and that the juries and or the judges would favor the home court plaintiffs. So that's the purpose. Now, many people would say, including I would gather many people on the faculty here at Duke, that those concerns are pretty antiquated at this point. Companies, I think one would be hard-pressed, especially with a company like my client, in that case Hertz, to say that in a state like California, where this case arose, that Hertz would be subject to out-of-state discrimination on the theory that Hertz's headquarters are in New Jersey. It's a New Jersey company. Everybody considers Hertz to be a New Jersey company. And when it's in California, state juries and state courts are really going to favor Hertz, are really going to favor the plaintiffs rather than the company. I mean, the idea, I think, has taken some hold with reason that companies like Hertz are national companies. They do business everywhere. They're not really subject to out-of-state discrimination in any state because they're such a household name. Does Coca-Cola, even though Coca-Cola is headquartered in Atlanta, maybe does a lot of business there, does Coca-Cola really, are they really subject to out-of-state bias in Pennsylvania? I mean, some people would say no. And the same thing with Hertz. So in terms of statutory purposes and statutory intent, at first blush, it seems like there's an uphill battle there. But if you think about it a little bit further, I'm not sure that that's really the case for the following reason, that Congress decided that there was one and only one state in which a corporation was going to be deemed a citizen, the state where it has its principal place of business. So there's only one state in which a corporation is disabled from removing a case to federal court. Everywhere else, by definition, a corporation can take the case up to federal court. So we're already past the point where we're concerned with the notion that corporations really aren't subject to bias in a number of states, because we know to a moral certainty that there's only one state in which a corporation is disabled from removing the case. So sure, it's true that Hertz, if you ask the question in the abstract, should Hertz have the ability to remove a California state case to California federal court on the theory that it might be subject to out-of-state bias there? One might answer that question, well, no. Hertz does a lot of business in California. They rent the most cars there. They have the biggest physical plant there. On any revenue metric, they do the most business in California. Incidentally, can anybody guess what's the single most active rental car location in the United States? If you had to pick one place. Yeah, LAX. Yeah, everybody drives in LA. So you can't take a train from LAX, as far as I know. So LAX is the single most active rental car location in the country. And so that is part of the reason that the Ninth Circuit had reached the conclusion in the Hertz case that California was Hertz's principal place of business, because if you look at the degree of activity, business activity that Hertz conducts all over the country, it conducted the most in California. Now, it wasn't by a huge margin. I mean, I think the figures were roughly 20% of its business in California, maybe 15% of its business in Florida. So you're talking about gradations rather than differences in kind, but still, largely because of LAX and because of the driving population in California, it was significant there. So would you say that Hertz is subject to out-of-state bias in California? Arguably not. But we're past that point because we know that Hertz can remove in 49 states. And I'm putting to one side, for the jurisdiction jocks in here, the notion that you can't remove in your state of incorporation either, but let's just put that to one side for now. So you can remove in 49 states. you can only not remove in one state. So it's necessarily true that there are multiple states in which a company does a lot of business, and nonetheless they're going to be able to remove the case. So really the purpose that's at issue is in which state is the corporation least likely to be subject to bias. Because once you've accounted for that one state, every other state is one where by definition under the statute, removal is possible. I thought that was a pretty powerful argument for us and a way to rebut the notion that purpose really counts against us. And the hypothetical that we came up with, and that I think does some work in this context, involves Walmart. Now, do people know where Walmart is headquartered? Right, Arkansas. Where do people think Walmart does the most business? Did somebody say Texas? Yeah, Texas. Yeah, pump your fist, that's good. It's apparently a Duke thing. Aren't you supposed to stand up and also touch the floor? And so, yeah, Texas is where they do the most business. Arkansas is where they have their headquarters. So if you think about the way these competing rules would work in the situation of Walmart, under a business kind of approach, you would say Walmart does the most business in Texas, and therefore they can't remove a case in Texas. They have to be in state court. There's no danger of out-of-state bias in Texas. They do tons of business there. You know, that sounds pretty plausible, right? They do a lot of business in Texas. I mean, maybe there is a limited risk that they would be subject to out-of-state bias in Texas. But think about the consequences of that. What that means is that they could remove a case in Arkansas because it's only one state where they can't remove. Now that, to me, seems crazy. Everybody thinks Walmart is an Arkansas corporation, but the result of fixating on the place where they do the most business is that the place where they have their headquarters would be one in which you can remove. And so the idea that that Walmart, a Bentonville, Arkansas corporation, could say that it's subject to out-of-state bias in Arkansas and therefore can remove an Arkansas state case to Arkansas federal court seems like a tough proposition to follow. And so once you understand that the way the statute works is it's a zero-sum game, it's like whack-a-mole. You know, once you have one state, that's it. Every other state pops up. I think it helped us a lot. And so that was a way to kind of rebut the notion that in terms of statutory purposes, we actually have a pretty good argument. It's true that in the abstract you could say, you know, Hertz is not subject to out-of-state bias in California, but that would mean that Hertz could remove a case in Park Ridge, New Jersey, where its headquarters are, even though Hertz is quite a big presence in Park Ridge, New Jersey, which seems like a difficult proposition to swallow rather. So that's some, you know, sort of what I would view to be kind of the relevant considerations in formulating a rule. And then you balance these off one another and you figure out which one is the best across all these metrics, even if it's not the best on every one, and do you have a defensible position on the rest of them. Now there's an important additional lesson that I would say, which is a fallback position. There's a pretty famous argument where Justice O'Connor, for whom I had the honor of clerking a few years ago, and it doesn't surprise me in the least that she would have said this at argument, was interrogating, for lack of a better word, an advocate who was putting forward a proposition, a rule that the court just wasn't swallowing. And it was, I think, you know, a lot of times with the cases, you're wrestling between a rule that's very, very administrable, simple in application and attractive in that sense, but it has some consequences that seem really difficult to swallow. And then your rule starts to break down and it's not as clear anymore and it becomes more of a standard. And it's, you know, well, we have a fail-safe for crazy circumstances. You know, we have an extreme circumstances exception to our rule. Well, then once you have the extreme circumstances exception, of course, the people who really like rules are bothered by the fact that the rule has a caveat in it and it's not as clear in application anymore. And this, as I recall, was one of these sorts of situations where the first order rule was a very difficult one to swallow because the practical consequences were hard to stomach. But the advocate was putting forward this rule and pressing it quite vigorously. And Justice O'Connor, at some point, after many of the justices had expressed misgivings about this rule, said, Mr. Smith, do you have a fallback position? And he said, yes, I do, Your Honor. And she said, well, I think it's about time to fall back. And so the lesson there is that the court can be a challenging place to argue because there are some justices who are really drawn to clarity and simplicity and straightforwardness in application, even if it's a difficult rule to swallow across the other metrics. But there are other justices who place a greater degree of emphasis on the facts and circumstances of individual cases and don't care as much about administrability and simplicity across the board. So in the Hertz case, for example, the hypothetical involving Venetian Casino that I outlined earlier, when I did my moot courts, those kinds of hypotheticals were tough because a lot of people just said, you can't possibly be serious that the principal place of business of Venetian Casino is Phoenix, Arizona. I'm never going to accept that. It can't be right. And so we had a fallback position, which was in a corporation that does a multi-state business and has dispersed operations. In that situation, the headquarters is the principal place of business. And that's all we needed to win because Hertz, by any measure, was a multi-state corporation with dispersed operations. It operated in many, many states, and it did a lot of business in a lot of states. But once you articulate the fallback position, you can immediately understand its weaknesses. What's a multi-state business? I know it when I see it. I mean, certainly Coca-Cola is one, Walmart is one, Hertz is one. But what if you do business in 3 states? Is that enough? I don't know. What's dispersed operations? The Venetian, you exclude that one because the operations aren't dispersed. Everything happens in Nevada. Everything happens in Las Vegas. So you could say that, well, in that situation, our rule wouldn't apply, and Venetian would still be deemed a Nevada citizen, rather, even though its headquarters are in Phoenix, because it doesn't have dispersed operations. Okay, well, what does it mean to have dispersed operations? That's a really hard term to define. I mean, in the mine run of cases, you can probably come up with a pretty wide degree of consensus on whether a company has dispersed operations, but it's easy to imagine hypotheticals in which you don't. So it's kind of this classic dichotomy. I mean, you forsake clarity for greater acceptability of outcomes, but by doing so, you forsake clarity by definition. And so that's going to be something that some justices, I think, are going to care more about, others less about. And I will tell you that we knew going into the argument that the kind of full-bore headquarters in all circumstances approach might be attractive to some, and that a caveated approach, which focused more narrowly on national corporations or multi-state corporations with dispersed operations, might be attractive to others. And it was uncanny. I mean, the beginning of the argument, I started out by articulating the headquarters approach, and immediately I got questions from some justices to the effect that, well, why do you have to have that approach across the board? I mean, why can't you just win by having a rule for national corporations with multi-state operations? Yes, Your Honor, we can, and at the very least, we think we should win in that situation, and this is clearly one. Then immediately, somebody else pipes up and says, but wait a minute, that's a completely ambiguous, hopelessly ambiguous approach. It should be headquarters across the board. So you may be in a situation where you're articulating different rules for different people, and at the end of it's challenging, it's hard to do. But at the end of the day, you want to win. You want to cobble together 5 votes somehow. And so you have to maintain some degree of nimbleness, if that's a word, in adjusting between the two kinds of approaches. So that's, I think, a kind of an overall schematic on how you formulate a rule, have a fallback. We talked about the considerations that one would take into account. Understand that they're going to offset one another in certain circumstances, and you're going to have to figure out which set of considerations is the most important. Any thoughts or questions about that? Yeah.
I'm interested in how your emphasis on certain considerations is changing the composition of court. Do you find that certain considerations, do they split along ideological lines, or is it kind of different splits on what considerations that you care about?
They do, I think, to some extent, divide along ideological lines, but I think there's a real methodological dimension to it, too. I mean, it's the case that some justices are, and is it Kathleen Sullivan who wrote the article about rules and standards? I mean, there really are justices who are justices of rules, and I think Justice Scalia has said the rule of law is a law of rules. And other justices who don't feel that same way, and they care more about contextual considerations and more fact-specific inquiries. And Justice O'Connor was often thought to be such a justice. Justice Stevens, who just stepped down, as everybody knows, was more in that camp as well. And so I think that is the divide that one often confronts, especially in statutory cases where you're trying to arrive at a rule. And you see this time and time again, that there's a competition between those two approaches, and the advocate is kind of caught in a whipsaw in some respects. So I think, to me, in terms of advocacy, the easier approach usually to advocate and defend is the clear rule, even if the consequences are hard to stomach. just as a matter of pure argumentation. I'm not talking about what ultimately sells in terms of persuasive force and what's going to motivate the court. But in terms of the back and forth of argument, it's usually easier to argue a clear and straightforward rule, even if the consequences are difficult to stomach, as long as you have something defensible to say about the consequences. Where you get into trouble is articulating a rule that has too much context in it, too many caveats. That can just lead to a difficult exchange with the court on hypotheticals. What doesn't cover this hypothetical? How do you define it for this hypothetical? So as a matter of pure argumentation, I think the normal approach would be you start off with the first order of submission, which is the full-bore, clear rule, and then you have the other one as a fail-safe in case you need it. Anything else about formulating the rule? All right. Well, let's talk a little bit about articulating the rule and a little bit about argument. Now, before talking about kind of the nuts and bolts of argument, I thought I would talk a little bit about just argument at the court and how it's changed a little bit. And I looked into this a little bit because I had the occasion to appear at a symposium on behalf of Justice Stevens put on by Georgetown, and Justice Stevens was there. And it was interesting I was on a panel of people who had been advocates before Justice Stevens. And I thought one thing that would be interesting to do in connection with this symposium was to look at how argument has changed over the span of his tenure. Just to put a little context on how we articulate positions in statutory interpretation cases, let's talk about what's happened with argument. So Justice Stevens came on the court in 1975. He obviously left the court in 2009. I looked at some of the arguments from the 1975 term just to get a sense of what the flavor of the back and forth was. And there was some pretty remarkable things. Now, this is not a scientific survey. I didn't do it systematically, so I don't know if these results hold up across the board, but still there's some interesting tidbits. 1975 was a pretty remarkable term because it was a term that came up in the fairly immediate wake of Furman versus Georgia, which many of you probably know about, invalidated the death penalty across the board. And then in the relatively immediate wake of Roe as well, which everybody knows about. And in 1975, there was a quintet of capital punishment cases headed by Gregg versus Georgia that essentially presented the question of, in what circumstances can capital punishment be imposed constitutionally now that Furman has said that the way it was imposed before is invalid across the board? And then there was a case called Planned Parenthood where Danforth, and the Danforth case, which was, I think, the first abortion case that came up to the court in the immediate wake of Roe. And I listened to those arguments on a great website called Oye Oye, if any of you are interested in this, that they have recordings of many of the important Supreme Court arguments in the past. But here's what's interesting about it. In the Gregg versus Georgia case, the capital punishment case, 9 minutes went by before the first question was put to the advocate. In Jurek versus Texas, which was a second of this quintet of capital punishment cases, there was one question in the first 10 minutes. In Danforth versus Planned Parenthood, there was 10 minutes before the first question. So this is a different era when Justice Stevens first comes on the court. There are other cases in that term, to be sure, where questioning was more active, including at the outset. But it is virtually unheard of. I think unheard of. You will never see that situation replicated in this day and age. It is an incredibly active, vigorous exchange at argument. And just to give a couple of counterexamples from a more recent era, there's a capital case called Bays versus Reese, which is one of the more important capital cases of the past few terms, where the question was the constitutionality of the method of lethal injection, the particular cocktail, so to speak, of chemicals that Florida was using. That was argued a couple of years ago. Don Verrilli argued that case. He's a terrific Supreme Court advocate. And he got 32 seconds before the first question came. Gonzalez versus Carhart was the partial birth abortion case, also from a few terms ago. Paul Clement, the Solicitor General, another fantastic Supreme Court advocate, had that case for the petitioner side. He got 60 seconds before the first question. And these are highly respected advocates from whom the court likes to hear. But still, they got 30 seconds and 60 seconds as opposed to 10 minutes and 11 minutes. So argument has changed a lot. It has changed. It is incredibly active now. We looked at some statistics last year on how the arguments went down in the last term and who was asking questions at what point. And just to put some meat on that bone, in case you're interested in these kind of statistics, there was roughly a total of something like 80 to 85 questions in an hour of argument. So that's a pretty rapid fire pace. And that's not counting a lot of things, because it's hard to know, what counts as a question. For example, with Justice Stevens, he famously and very politely and endearingly often set up his questions by asking, "May I ask a question?" And we decided not to count "May I ask a question" as a question, even though it is a question. But we thought that a question was something as to which maybe there was more than one viable answer, and usually when Justice Stevens asks, "May I ask a question?" there's not, no, Your Honor, actually, no. There's some other important business I want to tend to. So that's not viable. But you're talking about, something on the order of 80 to 85 questions in the span of an hour of argument. And they're coming quickly. So it's a different era in terms of argument. Just if you're interested, there's some pretty pronounced patterns with questioning. I know the justice for whom I'd clerked, Justice O'Connor, was pretty famous for often asking the first question at argument. I don't know how this came about, but the fact is there. And if you look at her last term, 2004, the questioning, the number of times a justice asked the first question goes like this. Chief Justice Rehnquist 5 times, Justice Stevens 4 times, Justice Scalia 9 times, Justice Kennedy 8 times, Justice Souter 6 times, Justice Thomas 0 times, Justice Ginsburg 8 times, Justice Breyer once, Justice O'Connor 29 times. So you can see these are, you would expect a random array of 1/9 for each justice, right? But it doesn't happen that way. There are patterns that emerge. And from last term, she's no longer on the court, but if you're interested, the people who asked the most questions, who most often asked the first question, were Justices Ginsburg and Sotomayor, who Ginsburg asked 20 of the 77 cases the first question, and Sotomayor 16 of the 77. In terms of overall number of questions, Justice Scalia was at the top, and the Chief Justice followed, and then you had sort of a troika of Ginsburg, Breyer, and Sotomayor, followed by Alito, Stevens, and then Justice Thomas. But you can't just ask about numbers of questions. You also have to think about them in a different dimension, which is length of questions, because some people ask fewer questions, but the questions tend to be longer. Does any of this matter? I don't know. I think it actually kind of does matter, because especially with the first question can often set the tone for an argument. You often see a situation in which an advocate is diverted from the path that he or she wants to take right at the outset. So it's kind of interesting to think about, who's likely going to ask me my first question? And you can look at these and you can get a sense of who is going to do it and what they're going to ask about, because often you can look at past arguments, know a little bit about the justice's jurisprudence, and get a sense for what they might be asking you about. Now, in terms of length of questions, who's going to ask me questions that occupy more of my time? The length of question was a little bit different than the number of questions. Justice Breyer was far and away the leader in terms of lines of transcript, if you look at lines of transcript. And then it went down from there, but he's sort of famously known for asking pretty detailed hypothetical questions, and that can sometimes take a little bit of time to get through. But they're very, very good questions and hard to answer. But it's interesting to think about it in those terms. Now, articulating a position before a court that's this active and this engaged, what should we be taking into account vis-a-vis the rule that we formulated? Okay, my rough rule of thumb, for what it's worth, when you're arguing at the court, is you have basically time to make 2 points for every 10 minutes of argument. That doesn't seem like much, because it's not. The number one goal when arguing a case at the court is to answer questions. At least that's my view. I think obviously you want to go up there making affirmative points, and you want to do your client's argument in the best way possible to serve his or her cause. But the best way you can do that is to actually address the justice's concerns. Because no matter how much we'd like them to understand how right we are, they can't understand that unless their questions are answered. So the number one goal when you're arguing a case is to answer questions. Just answer them. It's often overlooked, but it's hugely, hugely important. Now, the one time in an argument in which you have a little bit of leeway to make points is at the outset. So I think it's really, really important to figure out what are your best 2 or 3 facts. What are your 2 or 3 best points? And just put them at the outset. Put them right at the beginning, front load them, get them out. You may never have a chance to make them again. So you need to do that at the outset. And then you're going to be in a back and forth exchange where you're doing the court a great service by hopefully answering their question in a way that advances your client's cause. So I'd say 2 points per 10 minutes and maybe 1 defensive point for 10 minutes. Now, what do you emphasize in your limited time? What I would do is I would think about the considerations that we outlined at the outset. Text, administrability, sensible outcomes, fidelity to precedent, fidelity to statutory purpose, things of that nature. Figure out what your best points are, put those right at the beginning, and cobble them together. It doesn't have to be a seamless sort of opening, but I would just front load your most important points, get them out, and then be prepared for a questioning answer session after that. And I'm going to give you an example of what I did in the Hertz case, not that it was particularly brilliant or anything, but it's an example of how we thought about how to put the opening. And I'll also do one from Skilling, and then I'll stop and answer questions. But before I do that, I want to make, just as a clinical matter, answering questions at arguments, since that's what you're going to be doing a lot of. What do we think about when we answer questions? I can make some kind of obvious, trite points like give really good answers, be articulate, don't say a lot, things that's just not very helpful. So rather than doing that, I'll just give you a little schematic on how I think about answering questions. Most questions can be answered in one of two ways. I think the best way to answer a question is to give an answer that advances the ball. So you want to get a question, you want to turn it around, you want to address the justice's concerns, and you want to explain to the justice or judge in a court of appeals why it is that that question shouldn't be a concern and why actually the answer to that question helps your client. And one silly mnemonic that I always keep in the back of my mind for whatever it's worth, for those of you who want to do oral advocacy, is yes, but, no, because. What do I mean by that? So almost every question, it seems to me, especially at the Supreme Court, is, would your rule mean X? Would your rule mean Y? I have a problem with what you're saying because of this. And doesn't your rule mean the following? And in almost every one of those situations, you can answer it by saying, yes, our rule would mean that, Your Honor, but that's not a problem. It's not a problem because I've got another clause that kicks in that addresses that concern. It's not a problem because if you look at the way these things work out in practice, it turns out that that issue doesn't often arise because the incentives in the system are such that it's not going to permit it to arise. Things of that nature. So yes, you're right, but don't worry about it. That's one way. The other is no, because. No, with all due respect, that's not correct. And the reason it's not correct is because, actually, you shouldn't say reason is because. Reason is that, or because, but you get my drift. No, because. That's the other angle. Those are ways that you can sort of, advance your client's cause. The other type of answer, which we shouldn't lose sight of at all, is what I would call a getting back to zero answer, which means you haven't really advanced your client's cause, but what you've said is that the other side has a problem with that too. I know you are, but what am I, sort of thing. One great example of this, there was a fantastic case that I briefed, and Michael Dreeben, who was here at Duke, and many of you may have had his class. I mean, he is, and one way to understand what to do at Supreme Court advocacy is just to listen to Michael's arguments. But he argued a case called Georgia versus Randolph, which is a laboratory hypothetical law school case. I mean, you couldn't imagine a better case where the issue is, if two people come to the door of a house, the police want to come in, one person says, yes, come on in, the other person says, no, can the police go in? So you don't even imagine that these things come up in real life, but they do. Okay, so this one came up. So the person who was arguing for the proposition that the police should not be allowed to come in gets a question from the Chief Justice along the following lines. Well, your argument means that if I'm in a dormitory and there are 10 people who live there, that 9 people could say, come on in, one person says no to the officer, and that means that the person can't come in, the officer can't come in. That seems crazy. Okay, so Tom Goldstein, who was arguing that position, who ultimately prevailed, started to give an answer, but then you could just see that the light bulb went off. And he said, yeah, but they've got the same problem too, because under their view, if 9 people said no and one person said yes, you could go in. Now, did that answer really advance his client's cause? Not really, but it got him right back to zero, because what he said is, that question doesn't advance the ball, with all due respect, because they've got the same problem that I do. So you have to look somewhere else. You have to look somewhere else to get the right answer to this case. So that's what I would call a kind of getting back to zero answer. That's a different type of answer than a advance the ball answer. You'd always like to advance the ball if you can, but otherwise you'd like to get back to zero. Now, in terms of how to open, let me get back to that for a second. I will just read to you the opening from Hertz, and then I'll read to you the opening from Skilling on a different issue, and then I'll stop and answer questions. So in Hertz, as we started out talking about, administrability was an important consideration. I thought it was really important to put that front and center. And then statutory purposes, once you understand the notion that there's only one state in which you're disabled from getting to diversity jurisdiction, and you can get it in 48 states, I thought that was an important consideration to get out there too. Of course you want to wrap it in the text, and I knew that I had roughly 30 to 60 seconds. So here's how I started out. Judge for yourself whether you think this is effective. Actually, I was just about to read the Skilling opening, which wouldn't have made any sense in this context, so let me get the Hertz one out. Thank you, Mr. Chief Justice, and may it please the court. The diversity statute deems a corporation a citizen of the state where it has its principal place of business. The Ninth Circuit erred in holding the petitioner Hertz as a citizen of California, even though Hertz is headquartered in New Jersey and conducts over 80% of its operations outside California, and even though, under that court's approach, national corporations could regularly be deemed California citizens if they conduct operations in that state that are proportional to the state's population. The better reading of the statute is that it points to the location of the corporation's headquarters, the site from which a corporation directs and controls all the company's operations throughout all its locations. And that's particularly the correct reading when the statutory language is considered in light of two considerations. First, the strong preference for simplicity and ease of administration in jurisdictional rules. And second, Congress's purpose to preserve diversity jurisdiction for corporations in 48 states and to deny access to diversity jurisdiction only in one state, the state where the corporation has its home or principal place of business. And then I got out a couple more lines and then the questioning started. So what I was trying to do at the outset is to get out the notion that we care a lot about administrability. We care a lot about the fact that there's only one state in which the corporation is going to be disabled from getting diversity jurisdiction. And then a couple of little factoids that I thought were really helpful. I mean, it seems odd to me to say that California is Hertz's principal place of business, even though its headquarters are somewhere else, and even though it does 80% of its business somewhere else. So we got that out as well. So that's an indication of how your rule in formulation can translate into your rule in articulation, especially at the outset of argument. The last thing I'll do is talk a little bit about the Skilling case and then answer any questions. The Skilling case it had the honest services issue that I talked about. It also had a question about whether he got a fair trial in Houston, which we thought was a pretty strong argument, and the court disagreed with us ultimately. But it was a powerful case to be made that the city of Houston was poisoned against the Enron Corporation and especially against the people that were in charge of Enron. And we focused a great deal of argument for reasons that I won't belabor here on that jury question. It cut across all the counts. It would have been a clean win. And what we wanted to do at the outset of that case is just put the best facts front and center before the court on why Houston was a poisoned atmosphere. Just put them out there, and then let's see what happens. Now, that's a case in which it's a constitutional issue on whether he got a fair jury, but the same considerations on formulating a rule apply. And that is that we had a really good case on the facts, but as far as administrability, it was difficult to figure out how you define what's a fair jury, what's an unfair jury, what's a fair venue, what's an unfair venue. But I thought the best thing we could do is get out the best facts right at the outset on why this was unfair, and then hope that the court would think it was so unfair that they could come up with a rule that works. And so here's what we said. Thank you, Mr. Chief Justice, and may it please the court. The dramatic collapse of Enron had profound reverberations experienced throughout the Houston economy and citizenry. Countless individuals in the Houston area were affected, as the Court of Appeals explicitly recognized, so much so that 60% of the Houston veneer affirmatively acknowledged that they would be unable to set aside their deep-seated biases, or that they were angry about Enron's collapse, an anger that was manifested in the vitriolic terms in which Petitioner Jeff Skilling was referred to repeatedly. The passions about this case were so intense, and the connections to Enron ran so deep, that the entire United States Attorney's Office, all 150 so attorneys, recused themselves from the investigation that culminated in this prosecution. So that was, we had some good facts. The entire United States Attorney's Office recused itself, 150 attorneys. People were calling Jeff Skilling all manner of evil things, and this was all in the briefs. So I thought it was important to highlight that for the court to remind them that this was a citizen that really thought he was the devil. 60% of the people in the veneer laid bare that they were biased. These were really good facts, and I thought, given the limited time that we have to do something at the outset of the argument, the best strategy we can have is just put those facts in one hopper, get them out before the court, and then let's have an exchange about whether there's an administrable rule. Okay, with that, I'll stop, and I would love to answer any questions anybody has about anything, arguing, statutory interpretation. What do you wear when you argue? Whatever. Sure. Did somebody back here?
So you've talked mostly about kind of structuring an argument around kind of theoretical ideals that might appeal to a broad range of justices. How much do you actually tailor your
Well, you definitely can find yourself in that situation if it's a case in which it's pretty clear it's going to be 4-4 and you need the fifth vote. I mean, you just have to the extent possible, do the math ahead of time. And a lot of these cases present issues that have permutations that have already been addressed by the court. Sometimes you get the same issue again. But it's really important, and I think what your question highlights is it's really important to look at prior arguments and prior decisions and vote count and figure out which justices have which kinds of concerns, and especially to look at arguments. Because the justices, I mean, they're so well prepared and they're so adept that they've thought a lot about these cases ahead of time. And if a similar issue presented itself before, there's a reasonable chance that the questions that they would have asked last time are the same sorts of concerns they're going to have this time. So you definitely want to do the work to look at that, the backstory, and arm yourself with that information when you're going to argue. Now, if it's a case in which it looks like 4 justices are going to be one way and 4 justices are going to be another, then of course you absolutely take into account who the pivotal vote is, and you try to come up with an argument that's going to appeal to that person. And what this points up is there's a lot of times that argument where you give an answer that you know to a moral certainty is really going to frustrate some people on the court. But sometimes you just have to do it because you figure I'm likely, I don't know for sure, but I'm likely to get their vote at the end of the day. So the fact that it's going to be a little bit uncomfortable in the exchange right now where I give this answer in an effort to try to appeal to one person and it elicits probably a predictable response from somebody else to the effect that, you're killing me here. I'm really with you, but it's hard to be with you right now. A lot of times I think you have to think that that is worth it, that you're willing to forsake that uncomfortableness at the podium in order to try to articulate a position that's going to motivate somebody that you don't know about. Because the other people are probably secure enough in their feelings and in their position about the case that they're going to come around anyway. Yeah.
What strategies do you employ when one justice focuses on one particular issue and is really sort of commandeering the argument that's not necessarily favorable to the position, you have other issues you'd like to address? How do you sort of parlay out what that situation to get back to your argument?
It can be challenging. It can be really challenging, and especially I think it's related to the prior question. If it's a justice that you think you need, then you're going to stay there. You're going to do whatever you need to do. If it's a justice that you think you may not need or who has concerns that maybe others don't share, you're going to want to try to get out of it. Now, I'll tell you a little bit of a humorous story from one of the arguments last year. The one case I didn't talk about that I argued last year, also a statutory case, was an immigration case called Carachuri-Rosendo, and it had to do with an issue that's come up a lot about when an immigrant has committed an offense that qualifies as an aggravated felony. And there were a series of 3 or 4 decisions that had touched around this issue, and some of them had pronounced directly on it, but this raised a different permutation. And I had an exchange with Justice Breyer in the middle of that argument that went on for some time, where he was drawing on the past decisions and asking me a question, and I think it was my failing, but I could not understand the question, and I kept trying. And this comes up a lot in argument where you don't understand the question. And one strategy, a lot of times when you don't understand a question, is to assume that the question says one thing and just say what you assume it is and give an answer to that. And what I'll do a lot of times is I'll say, well, if what Your Honor means to be asking is, or if the concern that's underlying your question is, you sort of do it in a conditional way. Now, I tried that a few times and it just wasn't working. And he was getting, I think, understandably exasperated a little bit probably, and just we were clearly not connecting. And the other justices, I think, understood what was going on a little bit. And then finally at some point, and this was a vote that I thought that probably, I thought that we had a really good chance of getting Justice Breyer. So I wasn't quite sure how productive this was. And you don't want to say something that's unnecessarily going to cost you a vote somewhere else. So finally I said, and you can look it up, I think it's in the transcript, Justice Breyer, I have to confess, I don't know what you're asking me. And there was kind of, you see the notation in the transcript, laughter. And then Justice Breyer just said, just skip it. And then Justice Alito chimed in and said, can I ask you a question? I said, please, absolutely, please ask. So that's one strategy, but it can be hard. Yes?
How does your argument change depending on whether you're the petitioner or the respondent? Do you find yourself, let's say if you're the respondent, listening to what looks like it's come out at the beginning and really kind of adapting, or is it much more ahead of time?
Yeah, that's a good question. different people have different philosophies about what to do when you're respondent bottom side. I found, in my experience, that it's really effective when you get up second or third, if there's an amicus in the middle, to pick up midstream. I mean, obviously you want to have thought about ahead of times, what are the 2 to 3 to 4 points I want to get out there somehow? You know, there are 2 to 3 like factoids I want to get out, and you want to have thought about that. But if you're picking up the argument and you see where the justices are, and obviously you're paying very close attention to where they are because you want to understand where the fault lines are and where the concerns are, I find it's really helpful to just start up by picking up with a question and just saying, you know, I'd like to start out by addressing Justice Ginsburg, what I think was your question. And if that's something that's going to help you, and if that's a place you want to be anyway, I think it's quite effective to start out that way, because immediately you're going to get their attention. If it's more of a canned opening, then I think they're sort of thinking, look, we've all been sitting here for 30 minutes. You know, that's kind of interesting what you're saying mildly, but you know what we're concerned about, so why don't we get to that? So I find that to the extent that it's possible, it's really helpful to pick up midstream where they already are and address them right there. And say, you know, I want to pick up where opposing counsel just left off, which was on the following issue. And then everybody sees, okay, you're with me, you're understanding where I am, now let's hear what you have to say. And it's an opportunity to say something. Otherwise, you could run into a situation where you don't have any time because you start saying something that you had pre-planned and they're immediately going to chime in and get you where they want to be anyway. So, yeah. Or,
As a matter of technique, do you try to weave some of those illustrative hypotheticals into the brief, or do you save like the Walmart?
both. You definitely try to weave them into the brief. It is remarkable how much your thinking advances in preparation for argument. You swear to yourself that you've thought about the case as much as you possibly could have in briefing it. But then once you start focusing on argument, you think about it at another level. And so I think a lot of times these hypotheticals don't come within your field of vision until argument. So unfortunately, that's the reality. But if you can do it in a brief, yeah, sure, do it in a brief. I mean, I don't really believe that much in like saving something for argument so much. I think if you've got something good to use, you know, use it and see how it plays out in the briefing. And if it works, great. If not, you know, then you know that going in. Yeah.
One more.
Okay, sure. Yeah.
How do you deal with that? I feel like going through the brief writing process, you write the argument in a certain way, but then when you start talking about it and really working on oral arguments in a different way, how do you kind of harmonize what you presented in the brief with what you might think would be a better or more clear argument to use in oral arguments without contradicting?
Well, hopefully you're not in a situation where you're contradicting. I mean, usually you are in a situation where you're elaborating and making more clear, probably. And in that situation, I mean, let me say one thing first at the outset, that I used to be of the school of mind that the best brief is something that completely anticipates everything you might want to say at argument, so that it's all laid bare and there's little work to be done at argument other than kind of going over the highlights of your brief. I've come to realize, you know, at my old age at this point, that that's not always true. And there's nothing puts you in the crucible like oral argument. You can get away, you can write around things in a brief that you can't talk around. And so I think there's utility in certain situations in briefing a case and leaving some things unaddressed in the briefs, in part because you don't want to put yourself in a vulnerable position unnecessarily, and if you never have to, then great. In part because you want to leave yourself some room to think about it some more. So I think a lot of times you're going to be in a situation where you are actually doing the refining at argument, knowing that it's going to be an elaboration on what was in the briefs. And then in terms of articulating it at argument, I think it's totally fine. I mean, you rarely get a question at the court unless you contradict something in your brief to the effect of, you know, well, this is new to me. I mean, I wish you would have pointed that out to me before. I mean, if you're articulating it in the right way at argument, it's going to be grounded in something that you have in your brief, but it's just going to crystallize it in a better way. And so it should happen, and I don't think in the main that you need to be terribly worried about the fact that you hadn't highlighted it enough in your briefing. Because again, I mean, they're so unbelievably sharp that the justices are going to be there. And they're going to understand what you're saying. So if you have a great point to make an argument in a way that you haven't made in the briefs, make it. And that's what I would say.
I want to thank Sri very, very much for a richly illuminating discussion.